Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been following the high-profile case of State of Idaho versus Stacey James Wondra ever since the affidavit of probable cause was made public on the docket, which is available for the public to review free of charge on the State of Idaho's webpage, where high interest cases are located. I've provided a link into the description of this podcast episode. Mr. Wondra is accused in the tragic case of the disappearance and presumed unaliving of Michael Vaughn from his home in a small town on the Idaho-Oregon border called Fruitland. Earlier this year, there was an open and public preliminary hearing where the state of Idaho was tasked with bringing forward evidence in terms of witnesses and also physical evidence to convince the court that there was sufficient evidence to hold and bind Mr. Wondra over for trial, which the court made that finding that there was probable cause, that there was sufficient evidence to bind him over for trial, which is currently scheduled to occur September 14th, 2026. If you look at the docket, you'll note both sides have been busy preparing for trial by serving discovery, for example. And there are two notations on the court docket from March of 2026 where the state filed a demand for an alibi defense if Mr. Wondra will raise such an alibi defense at trial. Now, no person who is accused of a crime in this country can ever be compelled to provide testimony at a criminal trial based on the Fifth Amendment. They have the right to remain silent, but on occasion, a defendant will willingly raise a defense of alibi to essentially assert, for example, that I was at work at the time that the state is alleging that these crimes occurred. So therefore, I have this alibi, and the defendant would typically bring in evidence, maybe time slips, pay stubs, bringing in a supervisor or an owner of a company where that defendant was at the time of the crime to testify in his or her behalf. That's not saying that that's what Mr. Wondra will do. That's just an example when raising alibi defenses. Looking at the docket today, and it's May 5th of 2026, there has been nothing served from Mr. Wondra in the form of, for example, a notice of compliance with the state's demand for an alibi. There is nothing on the docket showing that any discovery was served by Mr. Wondra in compliance with the state's demand for discovery, supportive of a possible alibi defense. And there's nothing in the form of, for example, a motion for extension of time to respond to the alibi defense. So at this time, questions arise if he will even bring an alibi defense into the case, or will simply rely on the evidentiary standard that every government, whether it is the federal government or a state government who has charged a person with a crime, bears, bringing forward sufficient evidence at a beyond a reasonable doubt evidentiary standard that the person who is charged with a crime committed the crime pursuant to evidence brought in at trial sufficient to meet that high burden of proof, because at all times, Mr. Wondra and any other defendant, until or unless that person pleads guilty or is adjudicated guilty in a court of law following a trial, is presumed to be not guilty until such time that either a plea or an adjudication is rendered. We will continue to keep you posted as further developments arise as the matter styled as state of Idaho versus Wondra continues to move forward to this fall trial date. Until next time, this is Kathy. Thank you for joining us here today.